I'm Gary Venner, CEO of IFA Acquisitions, and I'm joined by Alex Canham, who's partner of Herrington Carmichael, where we continue our second informative question and answer series under our YouTube channel to provide top tips and market update when selling an IFA business and an insight into the legal processes when buying or selling an IFA business by two industry experts. The title of this mini video is coming up on screen now. So Alex, we've talked about non-compete clauses as covenants in contracts, but what other covenants and warranties and indemnities can we expect to see in contracts to protect, let's say to protect the acquirer to start with, and then we can talk about the vendor afterwards?
Most acquirers are going to require a set of warranties and indemnities regardless of what form the transaction takes, whether that's the sale of a client book and the trade and assets, or whether it's a share acquisition of a limited company. The warranties in themselves are really the buyer confirming certain bits of information about the business, and they're given in general at the point of completion for purposes of today. They are the assumptions the buyer is making, and ultimately if you don't tell the buyer those assumptions are incorrect through a formal process called disclosure, then the buyer has the right to come back to you and say, I think the business is worth less, or I've incurred liabilities as a result, and they can then pursue you for those. Indemnities are also used alongside that, and they're for a more limited range of matters generally, and we tend to see them focused on past advice and regulatory compliance before the date of the sale. And what they do is they give the buyer the right to come back to you as a seller and say, we've had an issue with advice you gave, or you've not complied with the regulations, and we've incurred some liabilities as a result of that. And ultimately, we want the seller to pay for those on a pound-for-pound basis. So indemnities are certainly a more buyer-friendly protection because they're not about the status of the business today or what's happened in the past. They are about something that will happen in the future.
And so am I right in thinking that PI cover could actually protect the vendor in that situation if in good faith they have believed to give good advice at the time, but something does unearth itself later on in that sort of period, and again is how long are they sort of on the hook for those warranties? But PI presumably does come into play here as well.
Very much so, and any seller should be insisting on that as part of the limitations on liability that would sit alongside these. So whilst it's perfectly reasonable and normal for the buyer to want these protections, it's also completely normal and standard for the seller to have various limitations on their liability. One of those being the PI. Now, the PI in itself will depend on exactly what the buyer's doing with the business. So if they're going to continue running it, then you'd expect the existing policy of PI to remain in place, and that be used as the primary remedy in the event there was a complaint or a sort of a matter that was covered by the policy. If they are going to deauthorise the business and close it down, then it's likely actually that will convert into runoff, and there might be obligations on the parties to maintain that insurance going forwards. Now, to make sure that these liabilities are not open-ended, you'd expect some time caps on those. And for warranties, we would typically expect those to be in the region of about 18 months to 2 years after the deal is completed. That's the market standard at the moment. For indemnities, it's generally a slightly longer period, and we are seeing anything from between sort of 2.5 to 3 years up to about 6 years. And it really depends on the nature of the acquirer and the type of advice that you've done through your business. So if it's perceived as being higher risk and the buyer is one of the more sort of cautious acquirers in the market, then they will tend to ask for a longer period of time. But it would generally be in that window for indemnities more often than not. The PI interaction is key though, because ultimately if a claim arises, even if PI is there, the buyer has control of how they manage that process out. And obviously they will have certain commercial considerations that they want to take into account, and making sure the client's looked after, making sure that their PI is not claimed on unnecessarily. So from a seller's perspective, it's really important to have in that contract some provision that says, in the event a claim arises that's covered by the PI, the buyer will use its reasonable efforts to try and pursue that in the first instance.
That makes loads of sense. And I mean there are so many changes as well there, whether it's a limited company or whether it's a partnership or sole trader as well there, isn't there? Because the limited company once that has been deauthorised by the FCA and it has been solvently liquidated, then the entity has ended. So really PI needs to happen right up until the point of the company being wound up.
That's right. So whilst it's authorised by the FCA, if it's directly authorised, then it's required to maintain PI insurance under the FCA rules in line with their minimum standards. When it's deauthorised, though, the indemnities under the sale agreement that make the sellers, in effect, personally responsible for those liabilities and those claims to the buyer, they will still exist more often than not. So having that insurance and an obligation to make sure that insurance cover stays and that we're clear whether it's the buyer or the seller and at whose cost is going to be taking out that insurance is really important. So that, to your point, you've got that cover right up until the end of the indemnity period. Because even if that company ceases to be deauthorised and is then liquidated, there is always the risk that a client makes an allegation against the buyer and the buyer incurs some form of cost or liability in connection with that, either as a result of them having to get involved in the process, potentially with the FSCS or the FCA, or similarly contemplating for a potential change in law during the course of that period.
Yeah, and you know, we have sole traders come to us to sell their businesses, and they've been in that sort of entity for many years. But you know, unfortunately for them, there is nothing you can do. But they do take that liability to the grave, because you know it's when a complaint would come in, and when a client is deemed to believe that they might have cause for complaint as well, because the clock starts ticking then, not when the actual advice was given. So you know, it's one of those things. I mean, there's not a lot you can do about it other than, you know, take at least run off cover for as long as you possibly can.
That's absolutely right, and sole traders are in the unfortunate position where they don't have an entity that they can potentially deauthorise and sort of distinguish from themselves, because ultimately when they get deauthorised as an individual, that liability still potentially sits with them. So trying to forecast when claims might be time barred is a very dangerous game in this industry.
Yeah.
So I think you're right. The sort of best practice would be to be liaising with your insurer and looking at maintaining some form of policy of insurance, certainly for a period of years after you've ceased to be authorised, to mitigate that risk.
And the same applies to trading partnerships as well.
Yes.
And of course then you have joint and several liability, which could all fall down onto one party as opposed to the other. So I think LLPs and limited companies certainly have a place for, you know, if you're in financial advice.
Very much so, and we would say it is a very small percentage of firms that operate outside of an LLP or a limited company structure these days.
Yeah. Subscribe to our YouTube channel and switch on notifications so that you won't miss our next video in the series of top tips and market update when buying or selling an IFA business, and an insight to the legal processes by two industry experts, me, Gary Venner, CEO of one of the UK's largest specialist brokers in IFA Acquisitions, and Alex Canham, partner from Herrington Carmichael, who are leading commercial lawyers specialising in IFA mergers and acquisitions.